He wants to know what is going on with this indictment on Eric Greitens, but we're the only ones who have the best when it comes to the legal expert. He's been quarantined for the last couple of days because he's had the flu, but we have pressed him into duty. Good morning, Greg Willard, professor at St. Louis University Law School and the KTRS legal analyst. Greg.
Good morning, McGraw and Kelly.
All right, so first off, can we assume that KS, the woman Eric Greitens had the affair with, is either working with the attorney, with the prosecutor, and or at least testified in front of the grand jury?
I think a fair assumption is that she has testified. The indictment, as it is required to do because of one of the elements of the charge against the governor, the indictment specifically says that the conduct was, quote, without the knowledge and consent of KS, close quote. So I think it's a reasonable assumption, McGraw, that the prosecutors and the grand jury have heard testimony from KS.
Will they have to release her name for this to go forward at some point?
That will be up to the presiding judge at the trial. And I think your question would be release her name publicly.
Right, yeah.
And so I think that will be in the discretion of the judge. I think most certainly KS will be required to testify because of the elements of the offense that has been alleged. But as to whether KS will be identified to Governor Greitens as his counsel, that most definitely will happen if it has not happened already.
In the indictment, and this is one of the things I noticed, but I don't know if anybody else has, and maybe it's a big deal, maybe it's not. It says there are three witnesses, KS, PS, and then JW. What can we glean from those three initials, and were there three witnesses to this alleged crime?
I'd be careful drawing too long of a line in terms of conclusions, McGraw. Keep in mind, this is just an indictment. This is just a charge, and the evidence that is presented to the grand jury is routinely not the amount and extent of evidence that would be presented to the jury at trial. So, JW that you referred to could be a very incidental witness, but the prosecution felt that JW's information needed to be provided in order to show probable cause.
Yeah.
But I wouldn't draw too much of a conclusion as to how many witnesses there are or how many witnesses there will be.
So explain the charge. He's charged with invasion of privacy. It sounds like it could have been a misdemeanor or a felony, but they chose to charge him with a felony. Why?
Sure. Let's break it down. In Missouri, it is a crime called invasion of privacy. And I'll quickly give our listeners, McGraw and Kelly, the four elements. One, the defendant knowingly photographed person. Two, in a state of partial nudity or full nudity. Three, without the person's consent. And four, in a place where that person had a reasonable expectation of privacy. Let's just stop right there. Those four elements make up the crime of invasion of privacy in Missouri. And that is a Class A misdemeanor punishable by 1 year incarceration and a $2,000 fine. In addition, there is what is called felony invasion of privacy, or as charged yesterday, first-degree invasion of privacy. And it has two additional elements. And those two additional elements are that the person who created the image up in the misdemeanor invasion of privacy, number one, transmitted the image in a manner, number two, that allows access to that image via a computer. So when those two additional elements, McGraw and Kelly, are alleged, and then combined with the Class A misdemeanor, it then is converted to a felony in Missouri. Now, used to be a Class D felony, and it is currently a Class E. But in March of 2015, when this crime was committed, it was categorized as a Class D felony, and that was what is the charge against the governor, and that's punishable by 7 years incarceration and a $10,000 fine.
Okay, so let's stick with the via the computer. I guess sometimes I've deleted a photograph that keeps on showing up on my different devices for years at a time, which I didn't necessarily download, but it keeps showing up on the cloud and everything else. Are they talking about that, or are they talking about where he actually sent it to somebody, or both? Or do we know?
Well, as you and I have talked on the air before, when we've talked about statutes and constitutions, words have meaning, and we have to be careful. And let's focus in on the operative word in the felony invasion of privacy statute, and that is transmit. Transmit the image in a manner, number two, that allows access by a computer. Well, that word, that verb, McGraw, transmits, I think could take a whole host of contexts and be applicable. Transmit by sending it via email, transmitting it to your Dropbox file, transmitting it onto a chip, a remote card, and taking that card and plugging it into your computer. Well, you've transmitted the image, and it has access on the computer, but it's never gone outside the four walls of your house, McGraw.
Right.
So I think the key to your question is focus on the word transmit, and I think we can take this from the plain language of the statute. That's a very, very broad term.
What do you make of Ed Dowd's comments that this statute was designed for peeping Toms and had nothing to do and does not apply to this consensual situation?
Well, I guess a couple of things. One, Ed, like any good defense attorney, yesterday down at the courthouse, very firmly stated his client's innocence and said that the statute under which the governor was charged was never intended to cover this activity. The governor then went a little further in his statement, and he made a direct attack on the prosecutor, Ms. Gardner herself, in terms of her prosecutorial discretion. Ed did not go that far. So I think what preview of coming attractions, I think what you're going to see early in the criminal proceedings is an attempt to have the motion dismissed, arguing that the words may say this in the statute, but golly gee whiz, that's not what it was intended. It was more voyeuristically driven, peeping Tom type of thing. It was not for this, and therefore it should be.
Yeah. Does it matter that it was written for a peeping Tom, and this just actually happens to fall under that because of all the things that line up in those four parts, as you mentioned?
Well, I think there is a large group of folks who, with no bias as to one side or the other in this litigation, would say that's what prosecutorial discretion is all about. In that a statute on its face and of the criminal definition may apply to conduct, but a prosecutor will say, no, that's not what was intended. I'm not going to exercise prosecutorial discretion. On the other hand, the people on the other side would say, no. And I think this is what we're going to hear from the governor. No. This is not a question of prosecutorial discretion. This is a legal question. And the statute was never designed, never intended by the Missouri legislature to cover this conduct, And court, as a matter of law, you need to intervene and say, no, we're not going to allow prosecutorial discretion to bring charges on this conduct with this statute.
Greg Willard,
and we'll see, Ed. Or McGraw.
Yeah.
We'll see whether Ed is able to prevail on that. I'll look forward to reading his briefs. As you and I both know, he is a terrific lawyer.
Right.
I guess the other comment I would make, just for our viewers and listeners, is the other part of Ed's statement yesterday. And I don't know what to make of it, but I would urge our listeners to take note of it and pay attention the next few weeks. Ed Dowd is one of the most distinguished attorneys in this state. He's a former United States attorney. I practiced law with him for many years. I former deputy special counsel in the Waco investigation. And the Dowd family is synonymous with integrity in the judicial system. When Ed Dowd stands on a courthouse in the state of Missouri and says, I have never seen such an outrageous charge in my 40 years of practice, our listeners and you and Kelly and I need to take note of that. We don't need to agree with what Ed's saying, but because Ed is saying it, we need to take note and keep our eyes on that part of this criminal proceeding.
All right, let me ask you this question, Greg Willard. By the way, you're tremendous. This is fantastic. St. Louis University law professor, KTRS legal analyst, Greg Willard. So in that same vein, let's go back to a Post-Dispatch article, January 11th, when this story first broke. Jim Bennett, Ed Dowd's partner in Dowd Bennett, was, and I'll read straight from the letter. It says, on Thursday morning, so this would have been back in January, on Thursday morning, Bennett added via email, no violence, no picture taken, no threat of blackmail. Yesterday, Ed Dowd sort of alluded to the fact that, okay, there might be a picture, but again, there's no crime. So Jim Bennett said 2 months ago there was no picture. Ed Dowd yesterday said, well, there's a picture, but there's no crime.
Again, this will all come out soon. In the governor has filed a motion to dismiss. He will be arraigned on March 16th down at the courthouse. So whether Jim's statement is at odds with Jim Bennett's statement is at odds with Ed Dowd's statement, we'll see how that plays out. I think the earlier statements that Jim and Bennett and the governor were so passionate about was the charges of violence or extortion or blackmail. Interestingly, we have heard no more of that, and we can search every word in the indictment, and blackmail and extortion and violence were not alleged by the grand jury. Rather, it's this first-degree felony invasion of privacy.
Yeah. All right, Greg Willard. Hope you feel better. You're the best. I hope you feel better just so we have you around as a resource. It's really, it's really all I care about.
As the saying goes, McGraw, I think this week I've had a near-death experience, but fortunately I did not see any white light. So I look forward to being back in the studio, my friend.
All right, sir. Take care, and thanks for your expert opinions. You're tremendous. Thanks.
Thanks, McGraw, Kelly. Good to be with you.
Greg Willard, St. Louis University law professor. Boy, that's about as good as it gets.
I mean, he really broke it down.
That is as good as it gets. And KTRS legal analyst.